0008, State of Ohio vs. Chancellor S. Krebs. Mr. Krebs is appearing by video from the Justice Center. His attorney is William Armentrout. He's appearing from his office. And, oh, wait a minute, I thought I had a prosecutor. Oh, yeah, there we are. Mr. King, sorry about that. Adam King is appearing on behalf of the state. The defendant was arraigned on the second on an indictment in this case, bond was set amount of $10,000. Since the arraignment took place in the absence of counsel, pursuant to Rule 46, of course, conducting a bond review hearing. So at this time, Mr. Armentrout, is there anything you would like to say regarding the matter of bond? All right, Mr. King.
Thank you, Your Honor. The state of National current bond remain in place. The defendant was in custody back in December in an unrelated matter. He was in a medical never returned after that. Ended up trying to escape. He was in court, and during the course of apprehending him, that's when these additional charges were picked up. So based on that, the state was just asked current bond remain. Thank you.
Anything else, Mr. Armentrout? All right, well, based upon the record, the court feels that $10,000 is an adequate an appropriate bond to ensure the defendant's appearance before the court. So the motion or the bail will remain the same thing. All right, have Brian Connolly, please, there to jail.
Yes, sir. Your Honor, this call should be she's trying to get in.
Yeah, she's connecting right now, it says, to the audio. I've admitted her, she's says she's connecting. If she's calling in from home, she may be having internet problems. So, all right, are you Brian Connolly appearing from the jail? All right, this is case number 22CR0021, State of Ohio vs. Brian B. Connolly. This hearing is being conducted by Zoom. Mr. Connolly's attorney is William Armentrout, appearing on behalf of the state as Assistant Prosecutor King. The defendant was arraigned on the indictment that was returned against him on February 1st and on the 3rd yesterday, and bond was set in the absence of counsel. So pursuant to Rule 46, of course, conducting this bail review at this time. Bond was set to now $50,000. Mr. Armentrout wishes to speak to the matter. All right, Mr. King.
Thank you, Your Honor. They just asked if they started the current bond in place.
Can you hear me?
Yes.
I actually have his file, and I believe they have a warrant out of Georgetown right now for his here.
All right. Well, looking at these charges, there are second-degree felony and a third-degree felony. Actually, there are also a couple of second-degree felonies and also a first-degree felony, all of which carry mandatory time. And so, given the nature of the charges, the court feels that that bond is the appropriate one to ensure the defendant's appearance in court. So, bond will remain the same. Thank you. Caleb Leonard, next, please. All right, you Caleb Leonard appearing from the jail. All right, this is case number 22CR37, State of Ohio vs. Caleb Leonard. This hearing being conducted by Zoom. His attorney is William Underchild, attorney in his office, attorney on behalf of the state's Assistant Prosecutor King. The defendant was arraigned on the charges yesterday, and bond was set in the absence of counsel amount of $20,000. So Rule 46, court required to conduct a review within 48 hours, so we're doing that now for 2 business days, I should say. Mr. Armchild, is there anything you'd like to say regarding matter of bond? All right, Mr. King.
It's actually this Collins, Your Honor.
Oh, okay. Oh, okay, go ahead.
I would just note, Mr. Leonard, that the allegations contained within the indictment, including the legal offenses here, the number of cases, count 9 is a felony 2 within the cemeteries named 30%, and again, 14 different counts of trafficking and possession. So he would ask the court to be $20,000 bond in place at the time for each case of the nature of these offenses. He does have prior to although they all are misdemeanors, right?
All right. Well, based on the seriousness of the offense, the numbers of the offenses, court feels that $20,000 is an appropriate amount to ensure the defendant's appearance. The bond will remain the same. Thank you. All right, is that all of your cases, Mr. Armchild?
Yes, sir.
All right, thank you. All right, let's have Lindsay Hornsby, please. All right, this is case number 22 CR 31, Dave, Ohio versus Lindsay Hornsby. Are you Lindsay Hornsby appearing from the jail?
Yes.
All right, this hearing is being conducted by Zoom. The defendant's attorney is Danielle Witt, attorney from her office, and also appearing on behalf of the state of the Anderson Collins. The defendant was arraigned yesterday on, actually on Wednesday, on indictment that was returned against her on Tuesday, along with 2 other co-defendants. Court set bail amount of $10,000 and pursuant to Rule 46, of course, conducting this bond review at this time. Ms. Witt, anything you would like to say regarding the matter of bond?
Mr. Honor, we request the court to reduce the bond for the bar bond. I represented that Lindsay in some municipal court cases. She does advise the community and is a child as well, so she was support towards. It is also my understanding that we heard the first time.
All right, Mrs. Collins.
Thanks for being on this one, Your Honor, right?
Oh, okay, somebody's just gonna have to tell me then. Hold your hand up when I call the name. All right, go ahead.
These are capital charges, the same gas, the current law remain in place. We also know, I'm not sure what address has been listed in her affidavit of indigency. However, she was apprehended at the location of the vehicle that's congregated. Thank you.
Yeah, you don't have an address listed, Ms. Hornsby. Where would you be residing?
It would be 663 Watergate Road.
What road?
Road, like, it's Grandma's house,
And that's Leesburg.
and that's the first one.
Or Lynchburg, I'm sorry. McMullen, okay. All right. Well, and then you say that's your kid's grandmother, so it's not your mother.
Yeah, I don't have, like, I can say that, that's where I was saying,
All right, well, I'm going to leave the bond in place at this point, but if we can get some information about the name of this individual and her willingness to accept responsibility for you, the court would reconsider. But for the time being, that remain in place. Julia Midkiff, please.
Can't find her. Let's see. There she is.
All right, are you Julia Midkiff appearing there from the jail?
Yes.
All right, this case number 22 CR 0017, Dave Ohio versus Julianne Midkiff. Ms. Midkiff is, as I said, appearing by Zoom from the jail. Her attorney is Danielle Witt, appearing by Zoom. Also, who's going to be representing the state on this one? Mr. King is representing the state. All right, the bond in this case was set around $10,000 on the charges that were returned against the defendant for burglary and theft. All right, Ms. Witt.
Yes, Your Honor, I'm not able to speak with this about this case. However, it is my understanding that she does have ties to the community and that she also is being held on some misdemeanor charges as well. We do ask the state, ask the court to reduce the bond.
Okay. Mr. King. Well, Ms. Midkiff, wait a minute. Wait a minute, Ms. Midkiff. You have an attorney, and I heard from her, and I'm going to hear from the state's attorney. Who's going to do this one, Mr. King?
And Your Honor, if this is burglary, the state would ask for a bond paid. Also, go ahead and bring this up now. I believe it's also raised in this court law. They're likely competency to serve this defendant. That's all I wrote.
All right. Well, I will note that we received an email from the Moritz Center,
Twin Valley.
Twin Valley. Apparently, there's been some sort of order out of the municipal court. I'm not exactly sure what. I'm going to ask that to have a conversation with the new judge to hopefully explain that competency to stand trial means trial doesn't mean competency to stand preliminary hearing. And so I don't think that the lower courts don't have any jurisdiction to make that determination. And so hopefully the new judge will maybe listen to that and make things easier on everybody. But in any event, I would note that I will raise that issue and order an evaluation be done on her because they were calling to determine what should be done. And I had my assignment commissioner email back and indicate that this court's position is that case, that order is moved now because the jurisdiction lies with this court, not municipal court. So we'll do that at this time. Now, in regards to the bail, I understand Ms. Midkiff is being held on other charges. She lists her. You want to say something about that, Ms. Midkiff? Okay. So there are no misdemeanor charges pending? Okay. Well, this is a serious offense, and given the issue of your mental state and the fact that you're homeless, and I also happen to see here that on August 19th of 2020, there was a warrant issued out of Lanchester for failure to appear. And given that, I think that at this point, I want to make sure that you will appear, so of course we're going to leave the bond order in place. And I'm going to go ahead and respond to order the competency evaluation be done by the forensic center. All right, thank you. All right, let's see. Is that both? That's the only one you have, Ms. Witt?
Yes, Your Honor.
All right, thank you. I'd like to see Stephen Nebo, please.
That's mine, Your Honor.
Okay. All right, are you Stephen Lawrence Debo?
Yes, sir.
All right, there are two cases before the court, 22 CR 28, 22 CR 39, Bill Style State of Ohio versus Stephen Lawrence Debo. Mr. Debo is appearing by Zoom from the jail. His attorney is Dennis Kirk, appearing from by Zoom, and then representing the state would be Andy Collins, the prosecuting attorney. The defendant was arraigned on both of these cases that were returned by indictments returned by the grand jury on Tuesday. He was arraigned yesterday. Bond was set in the 39 case at $5,000 and in the 28 case at $10,000. Since it was in the absence of counsel, of course, committed bond review here pursuant to Rule 46. All right, Mr. Kirk, anything that you would like to say?
Just like the case I'm not able to meet Mr. Debo yet, but the check the website does not appear to have any prior elements in this report. Appears that he was indicted Tuesday and immediately arrested, so he's in the area. He's from this area as well, and would ask the court to consider reduction of
All right, who's doing this one?
Yeah,
All right, Ms. Collins, go ahead. Go ahead, Ms. Collins. You have to say.
Mr. Kirk, there are no prior felonies, and he does have a few prior misdemeanor charges. I would note just the nature of these offenses, two separate cases, and these are trafficking offenses, including trafficking in the vicinity of the school zone. These are all that I believe that we should honor to really just based on the nature of these offenses.
All right. Well, after looking, I see he does not have any prior felony convictions of relatively small misdemeanor. So, in case number 22 CR 39, I'll leave the bond there at $5,000, and in 3028, I will reduce it to $5,000. So, be a bond reduction to that extent. So in 39 remains the same, 28 will be reduced. All right, thank you. Is that the only one you have, Mr. Kirk?
It is.
All right, thank you. All right, we need Seth Iger, please. All right, are you Seth Iger there appearing from the jail?
Yeah.
All right. This is case number 22 CR 33, State of Ohio versus Seth L. Iger. Iger is appearing by Zoom from the jail. His attorney is Jacob Wagner, also appearing by Zoom. The state is going to be represented by Mr. King.
Ms. Collins.
Ms. Collins, all right. Defendant was arraigned on the indictment, and bond was set yesterday. In the absence of counsel, about $10,000. Pursuant to Rule 46, the court is conducting a bail review hearing within 2 business days. So, Mr. Wagner, on behalf of the defendant.
Earlier, you said they asked for a bond reduction this time. I don't know. A lot of this is put up part of the case. But we also see that appear in the video. I say it was startling, but actually, I see said that every morning they get a coffee. So whereabouts of the community who seem to ask for bond reduction.
All right. Who's doing this one? Ms. Collins? Yes, go ahead.
Your Honor, I believe that they saw it too.
Well, we just lost her. Mr. King, you want to pick that up? I believe she's about to express her opposition.
I believe she's back in. I don't have this file with me.
Okay.
Given the nature of these charges, they are traffic offenses, it's the position of the state that will just make a
All right. Well, I reviewed the OCN report, and there's no previous felony convictions that I can find. There are 2 third-degree felonies, 2 fifth-degree felonies. Based on that, I'm going to reduce the bond to $5,000 plus all the other conditions in the arraignment entry. All right.
Thank you, sir.
Thank you.
Thank you. Thank you.
All right. Devin Sparks.
Your Honor, can you hear me?
Yes, I can now. You're a little. We lost you there for a minute.
Okay. So what comes with the knowledge transfer?
Yeah. Devin Sparks. Are you Devin Sparks appearing from the jail?
Yes, sir.
All right, this is case number 22 CR 22, State of Ohio versus Devin Sparks. This hearing being conducted by Zoom. Mr. Sparks' attorney is Pat Patner. She's attorney by Zoom and also attorney on behalf of the state would be Ms. Collins.
Yes.
The defendant was arraigned on the charges in this case. I believe in case number, I think it's 2 counts, 17 and 18. And Mr. Sparks, when I arraigned you yesterday, I got you confused with Gary Sparks. So I found out my error later in the day. So I think you were going to say something there, and the deputy talked to you. But yeah, you're only charged in 2 counts, not 4. So I did pick up on that later. So bond was originally set amount of $15,000. And pursuant to Rule 46, and bail was set in the absence of counsel, the court is conducting this hearing to review that. Ms. Hapner, do you wish to speak?
Thank you, Your Honor. I've not yet had an opportunity to speak with Mr. Sparks, however, I'm making the assumption that he's not been able to post bond. We would ask that because he's not under the penalties, and I know that your prior record is that his bond be released.
All right, Ms. Collins.
And Your Honor, just this is an aggravated trafficking in the vicinity of a school zone, which is a felony in the second degree, because of the bulk of mail. And according to CCH, was a prior one-degree conviction in 2018. Based on that, we would ask the question to bond in place.
What is that?
I just did 7 months.
For robbery?
7 months, and basically that's it.
Well, okay, that what I'm interested in is just your prior record. Were you convicted of robbery or not?
Oh, yeah, all the way back to 2000.
That's only a little over 3 years ago.
I had probation and all that.
You're on probation for that?
Yes.
Okay,
That's why I have.
all right. Well, since you have a previous robbery conviction, in this case, this charge is alleged to have been committed while you were on community control, and given the serious nature of it, the court will leave the bail as set. All right, thank you. $15,000. No, I said $15,000, but I said $7,500. That'd be half. I didn't say that. I said 15.
Mr.
Okay.
Sparks, I'm not speaking with you.
All right, thank you. All right, Jared Hill, please. All right, are you Jared Hill appearing there from the jail? All right, this case number 22 CR 36, State of Ohio versus Jared Hill. Mr. Hill, you were indicted by the grand jury Tuesday on two charges, aggravated trafficking methamphetamine and aggravated possession, both 4 felonies. If convicted of that, you could be sentenced to 6 to 18 months in prison and a fine of $9,000 on each count. You are entitled to have an attorney to represent you. I know you are represented by Mrs. Barber in your other case, and I believe you did fill out a new financial. Well, actually, Deputy, I don't have that. Did you send his financial disclosure form up? Oh, okay, well, you need to fill that out. I'll go ahead and appoint Ms. Barber to represent you, because I assume there's not been any change in your circumstances since I set bond for you the other day when you were arrested on a capious. And we'll go ahead and set your bond review hearing for, when is that set?
February 8th at 1:15.
All right, for February the 8th at
1:15, I believe.
1:15. We have that other hearing set at this time. I'll enter not guilty plea on your behalf and counsel. Bond will be set amount of $5,000 plus your own recognizance and $171 deposit for certain statutorily required fees prior to release. And then you'll be under, if you make bond, which you're not going to, I think I'm holding you without bond in the other case, but in any event, the standard conditions will apply. So Ms. Barber will be notified, and we'll see you back here Tuesday afternoon. All right, is that everybody in the jail?
I think we have Mr. Lanigan, but he's at 2, and I'm not sure if his attorney's Lanigan.
Oh, yeah, he's not on.
Yeah, his attorney isn't. Yeah.
All right. Mr. Lanigan's case will be at 2 o'clock here in a few minutes. I've got another case before that, so if you want to go ahead and get him set up. All right. Now, State of Ohio versus Christopher R. Hertzler, case number 21 CR 165. Okay, you're Christopher Hertzler appearing there on the screen, Mark. Christopher Hertzler. All right. Mr. Hertzler is represented by attorney Andrew Funzalita and Jeffrey Slyman. This is good afternoon. The defendant has been charged with a co-defendant in a multi-count indictment for various drug offenses. The matter was recently continued after ruling in the court to March the 28th. And then Mr. Rosalita and Slyman, I believe, filed a motion to withdraw. I believe I did overlook Ms. Collins. Are you representing the state on this one?
No, Mr. King.
Mr. King, all right, so Mr. King is going to represent the state. All right. The motion is to withdraw as counsel record. Now, counsel, have you and Mr. Hertzler have been in discussions regarding this matter?
Your Honor, you would advise that this would be the next step after the last pre-trial, in which we came to the conclusion that there was not being two.
All right. Mr. Hertzler, are you in a position to hire new counsel to be able to represent you at your trial on the 28th of March? Well, this case has been, I made a few notes. This case has been on the books since September. I believe it was arraigned on September the 20th. And we were supposed to be on trial Monday, which I did on my own motion continue as a precaution because of COVID-19 issues. And so at this point, the basis for the motion, one of the basis for the motions I read to counsel is that he's failed to allow you to handle the case in a procedure to obtain the best legal outcome, and wants to continue down a path that you cannot agree to take. I would point out that the course of action in a case is the client makes a decision. The Sixth Amendment guarantees defendants a right to effective assistance of counsel. It does not have a similar protection for attorneys. There is no right to effective assistance of a client. And in fact, prisons are full of clients who didn't cooperate with their attorneys, who didn't listen to their attorneys, and that's just the way it happens. So if he wants to exercise his right to trial and go against the advice of counsel, that is his right, and that's not a basis for withdrawal. So I'm not going to grant it on that basis. Now, in terms of the other thing is this is late in the game now. We got about 6 weeks to trial, and I'm not going to continue this case again. It's a big case. We've got a co-defendant. And it's gonna take probably 3 days out of the court's docket. And so I'm not gonna grant leave to withdraw unless he gets another attorney who will come in and commit to the March 28th trial. And so you need to tell them that, Mr. Hertzler, if you're gonna hire somebody, I'm not gonna grant another continuance. So the case is gonna go forward. So if you're gonna get a new attorney, you need to get on it and get it done ASAP, but make sure you tell that attorney, whoever he or she is, that the case is going to go to trial on March 28th. I'm one of those judges who doesn't believe in letting defendants come in at the 11th hour and say, okay, I don't like, what my attorneys are telling me, or the attorneys come in and say the defendant won't listen to me, which this judge knows is not a basis for withdrawal and won't allow. So just make that clear, because if you don't get a new attorney, then they're going to be represented. All right, you understand? All right. Anything further, counsel?
There.
All right. Thank you. I mean, a motion will be denied for the time being, subject to renewal if substitute counsel is filed, is found, and the court will then at that time grant. All right, thank you.
We also have Mr. Erskine as
Mr.
Lanigan and I forgot to tell you Erskine. Yeah, he is for Mr. Erskine as well.
Okay. Right.
Yeah.
All right, great. I didn't know we were ready to go.
Yeah.
Okay, case number 22 CR 18. Okay, are you David Lanigan there, appearing from the jail? All right. This is case number 22 CR 18, State of Ohio versus David A. Lanigan. And you're Douglas Brannon?
I am.
All right. Good afternoon. Before we go any further, Mr. Brannon, since this, I don't think you appeared in front of me at a Zoom hearing previously, but this court conducts Zoom hearings the same as if we're in court, which means counsel has to be appropriately attired. That means a shirt and tie and a suit jacket. So in the future, keep that in mind. I'll give you a pass this time, but in the future. All right. Now, Mr. Lanigan was indicted by the grand jury on Tuesday for trafficking in cocaine, possession of cocaine, third-degree felonies. He turned himself in, as I understand, this morning. Mr. Brandon arranged that, and I appreciate that. Does your client waive the reading of the indictment, Mr. Brandon?
Even though God is receiving that, we is really waiting because the source for all respectfully on that, it's like the counsel.
All right. Okay. We're doing right now, at least for the next month, anticipate doing most of our hearings, if not all, by Zoom. And so, first pre-trial, Mr. Brandon would be set for March the 2nd in the afternoon, if you're available. Probably say 3 o'clock.
You said 3 o'clock, Your Honor?
Yeah.
Yeah.
All right. Well, that'll be by Zoom. Final pre-trial would be April 13th. Same time.
April 13th at 3 o'clock.
Mm-hmm. Okay. Then trial date, April 28th, 8 a.m.
I have another trial set now. If that goes up, probably be.
All right. How about April 25? That'd be the previous Thursday.
Sure. April 25 is
Oh, I'm sorry. Oh, okay. So your trial starting on Monday?
correct.
Oh, okay. My mistake. Yeah.
The following week, as you do,
I don't have the following week available. How about May 9?
I have a mediation then from the starting then, it would be, what's the end of the week of May 19th, May 19th and 20th, the week of May 1.
No, I'm not going to be available then. All right, then here's what we'll do. How about April 14th? And I'll move your final pretrial up.
That's pretty soon, I'm not sure what we want this case yet.
It's a it looks like it's a one event trial. Alternative charge of one count of trafficking and one count of possession. So it seems to me it's a 1 day trial.
We can May 23rd.
No, it will not. We're going into April now. We can't go back. Can't go any further in the future. I just don't have the time.
Is it April 13th?
April 14th. Or April 11th, whichever works better. All right, April 14th. So then we'll move the pre-trial up to, how about March 17th in the afternoon?
They have probably a 2 to 3 week trial scheduled for March 7th through the 25th.
All right, well, then let's do this. Let's make, how about March you say, again, what were the dates?
That trial starts March 7th and goes through March 25th.
25th. All right. Oh, okay, I was just looking, I have a gap here and I understand why that is now. How about April 5th in the afternoon? All right, 3 o'clock. Those are, right now, that will be anticipated to be in person. All right, now, in regard to the matter of bond, the state which we heard on the matter of bond.
Thank you, Your Honor. Given that the defendant voluntarily turned himself in this afternoon, the state has no opposition to it or
All right. I was going to say, I assume you agree. All right. Okay, Mr. Lanigan, the court is going to release you on your own recognizance. That is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony. The deputy there will give you an assignment notice with your dates and time. And if there are any other hearings that are set that you fail to appear for, then you could be subject to being prosecuted for an additional felony, and if convicted, sentenced on that regardless of what happens in this case. Now, you'll be required to pay a deposit for service fees that are required by statute of $116. You'll have 30 days to do that so you can make payment arrangements with the clerk's office. Now, you're going to be under pretrial supervision of the probation department. With the weather conditions being what they are, I don't know that there's anybody down here today. So you are to report to them by noon Monday, February the 7th. Yeah, that's out to 117 East Main Street across from the Flagpole Station. You know where that's located? All right. So you report to them in person Monday by noon. Then after that, you report to them once a week for 4 weeks. After that, as they determine, you're going to go around and grant drug testing if they order it. Provide phone numbers for your home, cell, employer. If recommended by probation, you'll be evaluated for substance abuse and/or mental health issues. And if the recommendation is that you undergo any treatment, then you'll be required to enroll in that and follow that during the pendency of this action. What is your address, Mr. Lanigan? All right. And are you employed? Are you employed? Okay. Well, you'll be under house arrest at that address, meaning you have to be there unless you are working or going to and from work. Medical appointments, court proceedings for this or any other case. You have an appointment with your attorney or a probation officer. In this or any other case, you can attend that. You can attend any kind of educational programming, job training, vocational training, things of that nature. You can also attend church services. Other than that, you have to be there at all times. If you fail to comply with these conditions, then the court could revoke your OR bond, have you taken into custody and held until the court reviews the matter further. Okay, you understand? All right, thank you. Thank you, Mr. Bradley.
Thank you, Judge.
Okay, Ty Erskine, please, at the jail. Mr. Washington, thank you for being available. Didn't realize that they were able to get in touch with you yesterday. So, you're muted, Mr. Washington.
There we go.
Okay, all right. Okay, you are Ty Timothy Erskine, appearing from the jail.
Yes,
All right, this is case number 22 CR 34, State of Ohio versus Ty Timothy Erskine. This hearing is being conducted by Zoom. Mr. Erskine's attorney, David Washington, is present. Representing the state would be who? Mr. Ms. Collins? All right. And Collins, prosecuting attorney. All right. The defendant was indicted on Tuesday for, looks like, 3 counts of aggravated trafficking methamphetamine in the vicinity of school, 2 third-degree felonies, 1 fifth-degree felony, 1 count of aggravated possession of fentanyl-related compound, a 5th-degree felony, 1 count of aggravated possession of methamphetamine, a 5th-degree felony, 1 count of aggravated possession of methamphetamine, a 2nd-degree felony. Now, Mr. Erskine, I know, was served with his indictment, I believe, at least yesterday, because I did have him before the court and asked if he wanted to wait until he could talk with counsel. We arranged, he did indicate he did. He wished to do that, so I believe he's had it for more than 24 hours. So, Mr. Washington, does your client waive reading the indictment?
This time we'll waive reading, waive 24 reading to the defendant regarding service for being not guilty. Like we could have gone the appropriate time.
And you're in Cincinnati, are you, Thomas Washington?
I'm in a half, yes, in Boulder County, in Westchester, right now.
Yeah, I mean, your office is Cincinnati.
Yeah.
Hamilton, I'm sorry. All right, thank you.
As
Okay, go ahead and address bond, Mr. Washington, and I'll let the prosecutor.
the court's aware, he's actually out of bond on the case right now. This was, I obviously, I knew thinking about this indictment. He came out on Tuesday, I believe, he was arrested. He's been on pre-trial. This court, obviously, these are pretty significant charges. He wants to obviously do his trial in the appropriate way. I asked the court to consider, because I think he's on pre-trial release right now. I think we've done okay on that. But the court allowed him to be on pre-trial release, nor on these charges. I know there's 3 charges. He's done what he's supposed to this point. I don't know anything about this. Apparently, from investigation back in April, I believe. April last year, so I tried to tell anything about it.
April of last year, dates alleged, yes.
So this is all this all brand new. I had all. He has done, and looking at him, their jail actually. Let's all get to that Steve last couple times.
All right, who wishes to address that on behalf of the state?
Listen, my phone was on my service. Can you hear me?
Yeah, I can hear you.
Okay. Your religious point out that one of these charges is an F1, trafficking more than 5 times the amount of the city of school zone. The other charges are also bulk amount of meth trafficking. These are handgun lies based on this, as well as the charges that the 2 cases that he currently has pending, as well as his prior criminal history. The fact that he has previously had a prison sentence, we would ask the court to move on to the case, because we feel the same as not outrageous. These are the nature of these charges.
Actually, I haven't set the bond yet. I have to bring it yet. So.
Oh, I'm sorry. We would ask the court to set the bond on the American West Side Statement under the case. Thank you.
What is the bond in the other case?
One was 70,000 he posted, and I'm not sure about the first case.
I think they let that bond, let you allow that bond to apply to both cases.
Right.
And I believe, I don't want
was, you got a term.
I understand. I believe you're right. I think they were a combination of both cases. All right. Well, the matter that these kind of charges are pretty significant. First degree felony, second degree felony, those are mandatory times. I don't know. I don't recall what the other degree the other charges are. Okay, so I do wish to. I do feel that there should be a bond in place in this case because this case will not be set at the same time as the other ones, obviously, and so. Mr. Washington, if you can contact the bonding company, they're willing to have that bond apply to this case as well, and have them email something to the court or fax it something to the court in writing stating that they're willing for the $70,000 bonds posted in the other case to apply in this case, then I would allow that. If they're not willing to do that, the court is going to set the bond at $10,000 plus OR. There still will be a $116 deposit required for the deposit for the service fees. That's to be paid within 30 days. And then the same conditions apply in the other case, reported weekly or report probation. Again, I doubt if you're going to be able to get that all done today with the way things are, Mr. Hurston, so it's probably Monday. So by then everything should be better, so you'll report to probation as soon as you're released from making one. You'll be required to report to them once a week for 4 weeks, and after that, as they determine, we're going to random drug testing, provide phone number for home sale employer. If recommended by probation, be evaluated for substance abuse, mental health issues, and treats in a kid, roll in the file that for defense of this action. And then the other house arrest at your residence as previously ordered. I will say that the court has not received anything from the probation department indicating there's been any issue on this pre-trial in any other case. So, and you can represent that to the bond company, Mr. Washington, if that will make any difference. I don't know. All right, now.
We'll contact the bond company today, Judge. We appreciate the consideration tonight. I'll talk to your mom.
Okay, we're not done yet. I got to set the date for trial. Set the scheduling order. All right. So first pre-trial available on. Let's see, March the 2nd, Mr. Washington.
It just opens up, I want to make sure I understand. These are two separate prosecutors dealing with, on this first case, I believe, the gentleman, or is the same prosecutor?
We don't split cases in our office, there's only 2 of us, so you're not dealing with one or the other, it's Adam and Daniel.
Okay. I just want to make sure.
And that's false modesty, it's Annie and Adam. Yeah. I know Adam knows that. Okay.
The reason why I was asking is I think we have a pre-trial case scheduled for a Zoom hearing on the 16th at 2:30.
Okay, you think you'll be ready to do it then? That's 10 days?
I'm going to call the schedule.
Okay.
I still haven't gotten it. I think we just filed on the old case. In terms of sending it, I saw something on the website that just sent it out to me.
Okay. Well, okay, we'll go ahead and set it then. What time do you call? What time that one's set, Mr. Washington?
I have it set for 2:30.
All right, that's what time we'll do it then. And that'll be by Zoom.
Just to keep everything together, I mean.
Yeah, sure, for the pre-trials, we can do that. Now, that's your final, is that your final or first pre-trial of those cases? Final? All right, so then we'll need a final for this one. And so, how about March the 17th in the afternoon?
Actually, I can do that in the afternoon.
Okay, let's make it 2:30 in the afternoon.
That's perfect.
At this point, I'm leaving that open, as most likely will be in person, unless something happens between now and then to change that. And then,
Is that person done?
yeah, by March, I expect to be back in session in person in most of the hearings. We'll do some by Zoom as for convenience of counsel and or parties out of town, but most of the time we'll be doing those in person. All right, and then trial date then, I would say April 14.
I'm having trial that week ready to go.
Okay, how about, then the 25th of April?
Actually, around,
How long is that gonna last?
I'd say that's gonna be 2 days from.
28th?
That's fine,
Okay, 8 a.m.
that's fine.
All right. So, if you have, if the bond company will send something, to, confirm, and they'll need to have a case number and everything on it, Mr. Washington. And, just have them either email that to the clerk or the court, or fax it, whichever they want.
I will contact them, so they don't phone here.
All right, thank you very much.